The third main source of your employment rights is your contract of employment. Every employee has a contract of employment, even if nothing has been written down or signed. Employment contracts can be written down on a piece of paper or in an email. They can also be agreed to in person verbally. Usually your employment contract will be in one document. However, it can be made up of a combination of things which have been written down in a letter or email, as well as things which have been agreed to in person. Of course, verbal contracts can be much more difficult to prove. So if you have been promised something important, it's usually best to get it in writing. Generally, your contract of employment cannot give you an entitlement that is less generous than the laws that set out your minimum entitlements of employment, or an award or industrial agreement that applies to you. However, there are some exceptions to this rule. If you think that your contract is less generous than a law, award, or agreement that applies to you, you may wish to seek legal advice. You should also know that if there is a problem with your contract, you have 6 years from the date of the problem to file a claim. Now we're going to look at some common employment law questions people have when applying for a job and while working.